So while I'm in this graphic, let me just kind of show you the other one. Okay. In lien theory states, they use mortgages. And so, oops, other way. The mortgage is only a two-party instrument, mortgage or mortgagee. And we talked about these very early on in class because people have a tendency to get confused on these because you would think, oh, well, the bank gives me the mortgage. No, the bank gives you money. You give the bank, I froze for a second there, freaked me out. The bank gives you money and you give the bank the mortgage. And so here's the critical difference. In this lien theory states where they utilize a mortgage, you never sign away legal title. You still hold it as the borrower. You're holding legal title. If you look in the Register of Deeds, it says that you are legally owning it or holding it. But the mortgage still pledges the home as collateral for the debt nonetheless. You just haven't signed away the legal title. That's the big difference there. So yet again, if you default, they can go after it. But because they're not holding the legal title, it is what's called a judicial foreclosure. But you've got to make sure you understand the parties. The borrower is the mortgagor. In other words, remember the mortgagee is never me. Because you give the bank the promissory note, which yet again, evidence of the debt, promise to pay it back, and the mortgage, which pledges your home as collateral. Yes, I know if I mess up, you're going to come after the legal title of my home. But I'm still holding the legal title to my home. And what they give us is a loan. And then same thing, when you pay it off, they will record yet again a satisfaction. And that satisfaction will say, well, we no longer have the right to go after that home as collateral for the debt because they paid it off. So, big difference, right? Lien theory states, which utilize mortgages, are a judicial foreclosure process. You have to go through a court hearing to get the legal title before you can foreclose. In title theory states, power of sale foreclosure because they're already holding legal title. And I told you, nobody in any state would ever know the difference unless they were being foreclosed upon. That is the only time it's different. Folks, it's exceptionally easy to foreclose in North Carolina. Now, do the banks do it super fast? No. But it is very easy. They do not have to go through, it's literally just making an announcement at the magistrate's office. That's it. And then they can do it. So, title theory versus lien theory. North Carolina being a title theory state. We utilize the deed of trust, three-party instrument. And just make sure that you're very careful because as I'm sitting here explaining it, there is two very important documents. What you got, Bridge?
Yeah. Where can we access those charts you just showed us?
There are similar charts in your textbook, not the exact ones. I can take some screenshots and put them in the group me for you. Yep. So there's two main documents when you're purchasing a piece of real estate. Okay, that promissory note, which I told you is the evidence of the debt and the promise to pay it back. Okay, we're going to talk about the promissory note. It's got all the terms and kind of things that you can and can't do. And then, of course, the deed of trust, I keep telling you, is the security instrument. It is the one that says the home is collateral for the debt. And I talked about the act of pledging. When you're talking about the act of pledging, we call that hypothecation. Remember, root word being hypothetical, right? Hypothetically, I understand that if I default, you're coming after this house. Hypothecation. The act of pledging the home as collateral is called hypothecation. So the banks need that property as collateral to feel warm and fuzzy that they are going to get their money back and plus interest, and that if they don't, they have a means to get their money back. Now, folks, as you understand it, this is why appraisals are so important. They want to know the value of the property before they will lend on it, and that's why they're only doing the loan to value ratios that they are. They do not want to ever lend you more than what they think they could potentially sell it for based on the value of the property. It's very important to them. Now, certain things have to be held. These are both types of contracts, if you will, and both need to be in writing. And the deed of trust and mortgage are both recorded against the property as specific liens. That's kind of to protect the banks, as we said with like the Connor Act. The promissory note is not typically recorded. Can it be? Sure. But it is typically not recorded. Bank gets a copy, buyer gets a copy. So when we're talking about the deed of trust instrument, and of course there's parallels if we're talking deed of trust or mortgage, both would have to have legal descriptions of the property. Both would have to clearly identify the property or the parties to the agreement, have to be in writing, have to be signed. And of course, the big difference is one transfers legal title to the trustee, the other does not, just pledges it. So the deed of trust, as I said, whether you realized it or not, if you bought a house in North Carolina or any other title theory state, you turn around and you sign your legal interest over to the trustee. And so it's recorded in there. If folks, it's all public record too. If I cared enough, I could go and look at the Register of Deeds and I could see the most recent deed of trust on your property. And I can also see if you've refinanced, because there would be a satisfaction of that deed of trust and then there'd be a new one. It's all public record. We can find this stuff. It's recorded. Now, other things that are outlined in these instruments, obviously the rights and duties of the borrower. Folks, you've got this promissory note, which evidence of the debt, promise to pay it back. And it, of course, requires payment of that debt. Otherwise, the property is collateral for it. It also says that you're responsible for paying the real property taxes. It is arguably your house, or it will be completely and utterly your house at some point. I'm going to come back to the right of defeasance in just a second, but the maintenance of adequate insurance, yet again, you've got to maintain insurance on the property, maintenance of the property not allowed to waste. And then this is one that kind of surprises people. When we're dealing with the major alterations, it's actually a very common aspect of most deed of trusts out there that you are supposed to get approval from the lender before you make major alterations to the property. And a lot of people are like, well, why would that matter? Wouldn't alterations be, a financial benefit? And then you have to realize that some people think they're very handy and they're not. And so they may not be hiring a contractor, and making these major alterations could destroy the value of the property because you could mess it up. You could cause issues. So some people are actually considered in default if they make modifications without getting permission. Now, the right of defeasance is just basically it can go back to you after everything is resolved, paid off, and done, right? You transferred legal title to us, and it will go back to you as long as you follow the rules and you pay us off, and it's no longer collateral for the debt. And so think about paying off a home, folks. Let's say that you're selling. There is this deed of trust that exists that states that you don't technically hold the legal title. But what happens is when you sell the property and you get the money, the attorney is going to cut a check to the lender that you owe money to. And once they get that check, they will record a satisfaction, which sent the title back to you when they recorded their satisfaction, which now means that the deed that you gave to the seller at closing is good. The timing is weird, right? You give a deed to the buyer at closing as a seller, but technically they don't really get the legal no questions asked ownership until weeks later, because these things have to be recorded and then kind of goes back to you and then goes back to them and so on and so forth. The timing is weird. Now, any failure of any of these duties would result in a default. And we're going to talk about what happens when you default. I'm sure most of you know this, but it's not good. Now, the other thing that's outlined in these documents is the rights of the lender. And one thing that you may or may not realize that is almost always present is the lender always reserves the right to assign the debt. It's what we call a negotiable note when we're dealing with a promissory note. The way that banks work is very complex. Folks, sometimes when you're buying a home, the bank who originates your loan will have sold your loan off before you even make the first payment to them. Other times you make their first payment to them, and then after that, you're making it to somebody else. They will always, almost always put in there that they have the right to assign or transfer the debt. Think of the promissory note as an IOU. Whoever holds the IOU, you have to pay. Now, let's not get into the details of the deed of trust, because technically they do not always record new deeds of trust. It's just the way things are sold off. It's complex. We don't need to go down that rabbit hole. And of course, the foreclosure aspect is the other piece of it. It's very clearly outlined in the deed of trust that if you default in any way, shape, or form, they can foreclose, sell your home at auction to get the money to satisfy the debt that you owe them because you defaulted. And of course, not making payments is a default, making major alterations, a lot of things can be a default. Now, we said in North Carolina, we have the power of sale foreclosure. That is what happens in the title theory states, power of sale foreclosure. Because they're already holding legal title, it is very easy to close. No court proceeding. In lien theory states, judicial foreclosure, because they're not holding that legal title, they have to go through a court hearing to foreclose. Very different. Let me give you another piece of clarification, folks. Think back to when we talked about concurrent ownership, okay? And we talked about, joint tenancy and tenancy in common and tenancy by the entirety. Well, sometimes, even with things like joint tenancy and tenancy by the entirety, where both people are going to be on the deed, sometimes there is only one on the promissory note or the loan, if you will. Even for married couples, folks, if somebody's a stay-at-home spouse, there's no income to report. It doesn't really make a whole lot of sense to put them on the loan. You can, but then they're going to look at both credit scores and average the two under most circumstances. So even if only one is on the loan, since they're both on the deed, they would both have to sign the deed of trust or the mortgage in their respective states. Because the banks do not want any question of the fact that everybody signed their legal ownership over to them so that foreclosure is easier. So even if only one's on the loan, both would still have to sign the deed of trust or mortgage. And of course, a lot of these things I just keep repeating over and over again, right? Judicial foreclosure in lien theory states, non-judicial foreclosure, also called a power of sale foreclosure in the title theory states. And I'm sure you can already start to see why I'm telling you need to rewatch this video, because I'm speaking a different language for most of you folks. I remember when I started teaching this stuff and the amount of times I had to re-say it in my head to memorize it. It's a lot. Because it's just, these are not words that you've ever heard before, right? Deed of trust, mortgage, at least not in the correct context. And so I know it gets really confusing. Now, understand, folks, in North Carolina, when we're dealing with our non-judicial foreclosure, these homes get auctioned off, okay? They get auctioned off. They get auctioned off at the county courthouse. And of course, when you're dealing with foreclosures in both states, there is redemption periods where, folks, the banks want their money. So at the end of the day, if you could give the bank all the money you owe them, they'll stop the foreclosure. It's just that when you mess up, folks, we're going to talk about this, they basically speed up the maturity date. You had 30 years to pay us back $300,000, but because you messed up, you're going to owe us all $300,000 now. If you could pay it, the bank's fine. They say, give us all the money, right? Whatever it is, plus interest or whatever, they'd be fine. And so when you're being foreclosed upon, there is this potential to stop the foreclosure. Now, in North Carolina, the way that this works is the property gets auctioned off at the county courthouse. And after the auction ends, they leave it open for what's called a 10-day upset bid period. And what that basically allows is for the next 10 days, somebody could go down to the clerk of court's office and do a silent bid at the clerk of courts on that same property that the auction's already ended on. And anytime somebody does an upset bid, there is a new 10-day upset bid period. And the person who is being foreclosed upon could pay the bank their full balance at any time before the 10-day upside bid period ends and stop the foreclosure. It's just very rare that that happens, because if you couldn't even make your monthly payments, how are you going to come up with the full balance plus interest, right? Not very likely. But arguably, if you could refinance with another bank, you could stop it. So there's always this potential to stop the foreclosure, albeit not very likely. Now, here's where this also goes back to what we talked about earlier, folks. When somebody's being foreclosed upon and the property is sold, sometimes it is not sold for enough money to satisfy all liens. And so that would result in what we call potentially a deficiency judgment. Remember when we talked about lien priority? First in line, first in right. And so first recorded gets paid first. Except for what? What are the two highest priority liens on a property? Real property taxes and special assessments. There you go. Two highest priority liens. They beat out everything else, no matter when they were recorded, and everything else is in order of recordation, except for mechanics liens, which have that special rule that they kind of backdate to, when the work was started and materials were dropped off. But folks, understand what happens when this foreclosure auction goes through. They're going to remove all liens on the property, whether they got paid or not, because if they didn't, then people wouldn't want to buy it at auction. And so when somebody doesn't get all the money they were owed, or they don't get any money and the liens removed from the property, that does not mean that you don't owe them that money. But because the specific lien has been removed, they would have to go to court and file a deficiency judgment. So they could basically go after you by way of a general lien now, you as the person. It's called a deficiency judgment. So if there was a lien holder that was owed $15,000 and they didn't get it, they could go to court, file a deficiency judgment, and be able to go after you still for that $15,000. You, the person, not the property anymore. Now, this last note says this is prohibited on seller financing. Well, we're going to talk about this in a little bit, called a purchase money mortgage. When the seller is acting as the bank, meaning they previously held legal title, they are not allowed to file a deficiency judgment like a bank would, because of the vested interest they had in the property. It's just a quirky law. So just in case you see that, deficiency judgments are prohibited on seller financing in North Carolina. That's really the big takeaway there. Now, folks, I want to explain something else to you here, okay? There is some other concept that sounds similar, but it's not the same thing. It's called a short sale. And so a short sale, I think it's come up maybe briefly in earlier chapters when we're talking about like short sale addendums in the contract section. A short sale would be where you were willingly trying to sell the property as an owner, but you could not sell it for enough money to pay off all the liens. And so it's not a foreclosure. You would basically go to the lien holders and you would ask permission. I owe you $300,000, but I can't sell it and get that. Would you let me sell it for less than $300,000 and just take whatever I get? And the banks do not have to allow this, but sometimes they will. Why do you think the banks might go with a short sale? Yeah, Bridge says they don't want the property, and that's true. But I mean, even selling it at an auction, and they're still not going to hopefully end up with the property. Why else?
Avoid foreclosure.
Yeah. Typically, a short sale is the lesser of two evils in some instances. Why? Because it's going to be a very controlled sale listed by a real estate broker who probably knows the market. The other thing, too, when you're dealing with a judicial foreclosure in those lien theory states, that can be very expensive and time consuming. They're going to be spending a lot of money on the legalities. Now, of course, it's easier in North Carolina, but even still, the other thing, folks, right or wrong, even though it's not the bank's fault, if they're ever foreclosing on a buyer who decided they couldn't pay, wouldn't pay, or whatever, a lot of times buyers get disgruntled and they'll destroy the property. And so if they start destroying the property, it could have a value of 0, right? And so sometimes it's the lesser of two evils, so they may allow it. Plus, if you think about it, folks, think about the earlier example in this chapter where we just looked at a $200,000 loan at 5% interest. The bank made $208,000 in interest. They got their money back plus $208,000. And it's very interest heavy in the beginning. So it could be that if you're looking at doing a short sale in year 6, they could have already made $80,000 in interest off you. You know, it's very possible. So they may say, well, listen, we've already made a lot of money. Let's just roll with it to make our lives easier. But you cannot do it unless the lien holders agree. Because what they're doing is they are voluntarily agreeing to remove the liens on the property. Yet again, if they're not getting as much money as they're supposed to get and they remove these liens, they also could go after you for a deficiency judgment because they didn't get all their money. They don't have to forgive and forget it. So one of two things happens. They either file a deficiency judgment and go after you for it, even if they didn't get it, or they will forgive and forget it, but they will write it off as a business loss, which means it will get reported to the IRS as a basically free money for you, and then you'd be expected to pay taxes on that. Now, of course, a short sale, like I said, it's called that, not because it takes a short period of time. It actually takes a really long time. So there's a little bit of irony in the name. It is short on funds to satisfy all liens. Okay, that's what a short sale is. It absolutely would be a material fact. And if we were dealing with one, the bank gets the final say on whether or not they'd accept the offer or not. And so that's why we have to use that short sale addendum. Bill says, credit bilmish. Yeah, could be. Especially if they don't pay that deficiency judgment. Still arguably better than a foreclosure, but not great, right? Beverly says, are the banks dinged by the Fed for higher than normal foreclosure rates? I honestly couldn't tell you. I do not know that. I mean, they, of course, depending on the type of loans they're doing, have to meet certain underwriting guidelines. And so there's, structured criteria of what they're looking for to help minimize foreclosures. So I don't know if they're dinged or not. One last statement here on these short sales. Folks, I want you to understand something. If you have and by the way, I told you foreclosures and short sales are not the same thing. So you could have done nothing wrong and still be in a short sale situation. If the economy tanks in a certain area where like houses are selling for $400,000, maybe a big business closes down and people lose their jobs and the seller did nothing wrong, but now the $400,000 house they bought, they couldn't sell it for more than $380,000. It's not always they did something wrong. Sometimes it's just the economy changes in an area. But this third bullet point says seller does not bring additional funds to closing. If you owe the bank $400,000 and you can only sell for $380,000 and you have $20,000 in the bank, you can just give the bank the other $20,000 and walk away scot-free. There's no harm, no foul. That would not be a short sale. It would suck. It'd be a bad investment. It'd be a loss, but it's not a short sale. So what we're saying is you don't have the money to pay the bank what you owe them, and you're wanting them to take less than what you owe them. And they may or may not agree to it. So here's the $1 million question. How do you feel about the financing chapter thus far as compared to some of the previous ones? Parker, it's like that? Yep. Yep. Not too bad? Okay. Says the person who came in an hour and a half into it. Brooks says, bruh. I know. Yeah. I know. Now, this is why I told y'all that you will probably want to rewatch this video. No? Not gonna happen? 2 to 3 to 4 times? Is that what you're saying, Brooks? Okay, 2 to 3. Yeah. I was trying to figure out the code. He's like, gang signs? No. Just 2 to 3 to 4 times. Yeah. Yeah, it's a lot to soak in. That's exactly right. And that's why I'm telling you, folks, it would be impossible. Like, I can't spend 5 nights on this because we only have like 6 nights total left. But it's just, you got to hear it over and over and over. Yeah, definitely rewatch it. It's just a lot to take in because there is just so much to it, so much vocab, so much specifics, right? I mean, even just like deed of trust versus mortgage and lien theory and title theory, mortgage or mortgagee, right? There's a lot of language and vocab. Janet says, when is the last day of class? Next Wednesday is the last official class day. And timing wise, that should end up, we're still looking where that should just be nothing but our day of review, which means we're really going to get through all the chapters between tonight, tomorrow, and Wednesday, and then Monday, Tuesday of next week. And then Wednesday should just be review. But I told you, a lot of these sections are short, sweet, succinct. Some of them are not. Financing is not one of those, but some of the others are. So, I know. God, it went by fast, didn't it? Yeah, feels like it did. It's okay. All good things after that. You just got to pass your test. Then you got to pass your state test. And you got to get your license, right? Just in time for the holidays. Whoop, whoop. There you go. Was fast. So let's jump back into the financing section. See what else we can get into before the end of the evening. Talking about short sales. Now, just as a clarification, folks, and I doubt it's really going to get in this style of question, but just so we're all on the same page, there is some negotiations that have to happen with the bank on like what they would let it sell for, right? What it would list for, what they would be okay with accepting, things of that nature. That's not something we can do as a broker because, yet again, that would be the unauthorized practice of law. So the seller could hire an attorney to help them negotiate with the bank, or they could negotiate with the bank directly. But we are not able to do that negotiation. We can talk to the bank and say, would you accept this offer? But we can't try to negotiate the workout agreement or anything like that on behalf of our clients. So as a point of clarity there. So we've been talking about the different documents and some of the things that come with these, foreclosures and, defaults. We're going to get into that a little bit more.